Okay, this is the Civil Rights Lecture. It's from William Chafe's The Unfinished Journey. And it's chapter 6 in that book. I hope you watch the, first you watch the Emmett Till bit from Eyes on the Prize. And the Chafe lecture can also be found on the course materials or information on Blackboard. Okay, so civil rights movement, if I was teaching this class back in, let's say the early 70s, this would be the perfect bookend to the course, because we begin with the course with the discussion about Reconstruction, and then we move through civil rights, which would end the course nicely. But we keep marching on in history, and so here we are in the 21st century. And to be honest, the civil rights movement hasn't been completely successful yet either. But the way to think about civil rights is that it's rectifying the failures of Reconstruction. Excuse me. So we saw with the end of Reconstruction, the reassertion of local authority, the acceptance of segregation, the shoving down into inferior positions in society by the white majority to the African-American minority. And so this is in the nation, it's generally referred to as Jim Crow. But in the South, Jim Crow is, as we saw earlier, de jure, is a function of law. So this is an issue of Jim Crow, which is segregation, and it's which is directed in function through local and state authority, which is bumping up against this issue of federalism. And federalism is the assertion by the national government over the powers of the state government. So this is civil rights is a story that's related to Reconstruction and also related to this assertion of federalism. We saw with previously talking about the Supreme Court case Plessy versus Ferguson, which created some magic language, which said, which undergirded all Jim Crow legislation, because it said that separate facilities, which is what segregation law creates, are constitutional as long as they are equal. And so the magic phrase in Plessy versus Ferguson is separate but equal. Chafe does a nice job of highlighting what is sort of the triggering event for challenging the structure of Jim Crow and the whole segregation system. And he ties it, I think, quite accurately to World War II, because the experiences of World War II created a juxtaposition of a world that people saw that was different than the world they experienced under segregation, particularly the Black population. So you have soldiers, African-American soldiers who are in the military, who are serving all around the world, and they see completely different systems from the segregation oppressive system they experience at home. Also, being in the military, some of them are given position of responsibilities, and they have an opportunity to do things that they're prevented under segregation. Segregation treats the subjugated like they're children. They can't be given any authority or responsibility unless they're committing crimes, and then the responsibility is onerous. But this idea that the Black soldiers experienced seeing a wider world and having an opportunity to have a direction and say over other people was something that when they came back to the South, where these things are installed by law, they said, we're not signing up for this anymore. This has got to change. The other thing too, for people who didn't go into the military and travel around, it's an odd statement to say, but segregation and racism is a luxury. The same way that sexism is a luxury, because what you're doing is you're throwing away the talents of a segment of your population. During the war, World War II, this was a luxury the nation could not afford. It was something where all hands were needed on deck. As men were drafted and some women were incorporated into the military, you had an enormous demand for labor. So much labor demand that you couldn't throw away the talents of a segment of your population. So a number of people left, even if it was only temporarily, the Jim Crow South and went to places like Wichita, where they worked in the Boeing plant, where they made much better money than they would have made in sharecropper status. And they experienced a world that was different than the very oppressive local world in which they came from. So the combination of these two things, seeing a wider world through the eyes of movement for the war effort or being inducted in the military, they were the spark or the smolder that that was bubbling along or burning along that said, we're not going to tolerate this stuff. So the thing about, if you think about Plessy versus Ferguson, and you think about Jim Crow, so what does Jim Crow set off? By restricting and taking away the rights of African Americans to vote, you remove that lever from their hands. How do you change the system if you don't like the laws? Vote in new people who change the laws. Well, you can't vote in new people because you're prevented from voting, right? So that lever of control is out of the hands of African Americans. The other thing you can do is challenge it in court. Well, Plessy versus Ferguson at the Supreme Court said segregation law is constitutional. So you really don't have an effective way to challenge this body of laws known as Jim Crow. How do you challenge it, right? So Chafe envisions this in the following fashion, and I like this sort of structure. And he says, the first assault on the system of segregation, Jim Crow, that becomes known as the civil rights, is a challenge in the court system. And it goes back to that language of Plessy versus Ferguson, which said separateness is constitutional as long as the separate facilities are equal. Well, it's no big secret, but here's the reality of Jim Crow. They got the separate part down, but they sure as hell weren't equal, right? So if these cases could get into a federal court where they would be heard by an impartial federal jury, well, then they're kind of easy to win. Because if you're challenging the equal part, these things are not equal. The school system for the white children receives a lot more money, has new textbooks, has better facilities and better paid teachers. When you compare it to the school programs that existed for Black children in the South, they're way inferior. They're not equal, right? So those are easy cases to win, although it takes time, if you can get them to the court. So the first assault through the court system centers around this idea of equal, in that magic phrase, separate but equal. And so you have cases that are such as the Missouri law case, and I'll tell you what that, I'll give you an overview of what that is. In the state of Missouri, by law, a Black man could not go to law school. If you wanted to be a lawyer and you were African American in Missouri, you had to go to law school out of the state and then come back to the state and practice law. It was illegal for you to go to the state school system for law in the state of Missouri. Well, that's clearly not equal. Each state has their own body of law. And so going to the courts and arguing in a federal court case that this is not equal training or equal opportunity for African Americans who want to be lawyers in the state of Missouri, the court ruled correctly. That's not equal. So it violates the terms separate but equal under Plessy versus Ferguson. So law schools that are states that have made it illegal for people to attend school based upon their color, those laws are illegal, right? So the Missouri case says that you can go to law school. So Oklahoma, who is not part of that case, well, they had that same law in their book, so they have to change it. So what does Oklahoma do? So they say, okay, we'll admit Black students, but Black students have to sit in a special segregated section of the classroom. They cannot speak to their instructor during class. They are prevented from interacting and engaging in various things with their fellow white classmates. If they have questions, they can go to the instructor's office hours and raise their questions. They can't use the regular library. They've created a special Negro library, portion of the library, which has law books in there, right? So this, again, is not equal. It's an easy case to win if you can get into the federal court system. Part of law school training is engaging in debates and moot courts and doing things where you interact with other students. The material put aside for the Black students in law school was way inferior. They were old, outdated law books. They didn't have access to the main library. Easy cases to win. But each one of those cases, when you win it, it eats up a lot of time challenging it, right? So you have to work your way through the court system till you get a definitive ruling. And then what happens is the states in which those rulings would apply to figure out ways to circumvent it, leading to another round of court cases. So challenging the equal part is successful, but it's time consuming, this first assault in the courts. That's what makes Brown versus Board of Education such a dramatic ruling. Brown versus Board of Education was argued by Thurgood Marshall, who later was added to the Supreme Court. He was not the Supreme Court at that time. So Thurgood Marshall is arguing a different component of this challenge to Plessy versus Ferguson. Instead of arguing the equal part, cases that challenges have been won in the federal court system pretty consistently, Thurgood Marshall is going to challenge the separate part of this equation, right? And so he's going to do so in a certain way. He's arguing that the simple fact of creating separation, which is the intent of segregation, creates inequalities. And so this is what Thurgood Marshall is going to challenge. And it was a very divisive idea in the civil rights community, because they said, you're arguing a case that if you lose, it's going to entrench Plessy versus Ferguson for years, right? So you cannot afford to lose this case. And they didn't have a lot of faith in how he was arguing it. And so one of the things that is a function of the way the law works is that, especially the Supreme Court, when the Supreme Court issues a ruling, it establishes a baseline, what's known as a precedent. And the Supreme Court makes its ruling based upon precedents. So there's this whole architecture of legal results that courts, federal courts and Supreme Courts have ruled upon that the Supreme Court justices consult. So the coin of the realm is court cases. Thurgood Marshall was presenting evidence in this Supreme Court case that's heavily relying upon material that's not part of this. He can't rely on material about precedents because segregation law has been validated by a Supreme Court decision. And that whole body of law created a magic phrase, separate but equal. So he is going to challenge it in a different way. And this is a way that was risky. There is one of the strongest pieces of evidence he deployed to support the notion that separation creates inequality. There is a psychologist by the name of Joe Clark. And Joe Clark ran an experiment, and he took kindergartners, white and black, boys and girls, and he showed them different dolls. He showed them a white doll, and he showed them a black doll, and he showed them a white boy doll and a black boy doll. And then he asked them for questions. These are kindergartners, by the way. And so the comments from kids, white and black, about the white dolls were smart and strong and popular and nice and things like that. And the comments about the black dolls were stupid, dirty, lazy, all sorts of negative things. And what Clark interpreted from that experiment was that even as young as kindergartners, these children understood that they were being separated out by their race, by their color, and that one group was superior and one group was inferior. So what Clark's evidence was used by Thurgood Marshall to argue is that the mere act of creating separation creates inequality. And so no type of separation law or segregation law can pass the constitutional amendment, the 14th Amendment, that says we're all equal in the eyes of the law. So one of the things that I've always kind of liked about the Supreme Court is that they operate on their own time frame. So the case is argued before the Supreme Court. And then the court makes their own decisions. And what happened between when this case was argued and before there's a ruling, the Chief Justice of the Supreme Court died. So Eisenhower needs to appoint a new Supreme Court justice. And he named a man by the name of Earl Warren, who was a conservative Republican voter, I guess. And so Eisenhower thought that he'd be a good fit for the Supreme Court. Eisenhower later called it the biggest mistake he ever made, because Earl Warren on the court didn't act in the way that Eisenhower and other Republicans anticipated. And it's because of Earl Warren's history. Earl Warren was the state attorney general for California during World War II. And he had helped write some of the law that was used in the Japanese internment program. He wrote some of the legal justification for it. And he always regretted it. He knew that that was not in the spirit of the Constitution, that it was a mistake, that it was a racist mistake, and he had contributed to it. And he felt a lot of guilt about that, and he wanted the opportunity to rectify things in the future if he had a chance. Well, he gets his chance here with Brown versus Board of Education. He's made Supreme Court Chief Justice. And as Chief Justice, he says, I want to hear the arguments on Brown again, right? So they come in to argue the case again. And then it disappears into the whatever's going on in the Supreme Court. We now know behind the scenes, the following thing happened. Warren understands all Supreme Court rulings are equal, but some rulings are more equal. And he also understands that this ruling is going to be divisive. So after the case is argued, he solicits, the input of each of the justices. And he discovers that, as he hoped, that the justices were going to vote in favor of Brown in the case, and were going to overturn Plessy versus Ferguson. So Warren then put the pressure on the justices who were going to vote against that. And he said, look, you're in the minority. This case is going to be ruled in favor of Brown. It's going to overturn Plessy versus Ferguson. I should also say this about overturning Supreme Court rulings. Supreme Court justices hate overturning Supreme Court rulings for two reasons. One, it's enormously disruptive because that previous Supreme Court ruling has built upon it a whole architecture of laws that are modeled on that decision. So when you pull the rug out from one Supreme Court ruling, you're actually upending a whole body of legislation that is built upon it. So it's not something you want to do often, right? Because as the law works, it's built upon precedent. The other component about this is a personal one. Supreme Court justices are fearful that if they overturn previous Supreme Court rulings, some other Supreme Court justices are going to come along and overturn their rulings, and they hate that, right? So this whole idea of overturning the law is difficult. It has to be something that's crying out for a revisiting. So the Supreme Court as a whole rarely overturns. Doesn't mean it doesn't happen, but it rarely happens, right? So Warren says this is going to be overturned. And so he puts the pressure on those justices who were going to vote against Brown to say, look, we need to speak with one voice. Because if it's a 5-4 ruling, that's going to signal to people who are resistant that if we get a new Supreme Court justice, maybe we can reinstall this whole segregation system. He says, overturning separate but equal means the end of segregation, and we're going to have to speak with one voice. And so he was effective in this behind-the-scenes lobbying to get the other justices to go along. So on May 17th, 1954, this too I like about the way the Supreme Court operates, the ruling's not official until it's read into the record. And the Supreme Court announces they're going to be issuing some rulings, but they don't say, at 1 o'clock we're going to talk about this case. So it was about an hour or so in, the clerk was reading a ruling, reading in all the official documents. And then he says, and now I'm going to read the ruling on Brown versus Board of Education. And I always, old movies show whenever news breaks, you have the newsman run into the pay phone and then yell, stop the presses. And that type of scene is the one that always goes through my head when I think about this ruling, because an hour or so into, talking or reading into the record these rulings, the clerk announces they're going to read Brown. So all these reporters run to alert their colleagues and also to stop the presses because they know how dramatic this is going to be. What this does is it says the language of separate but equal is no longer operable. It's pulled out the Plessy versus Ferguson, which pulls out with it the whole body of Jim Crow legislation. By ruling it unconstitutional, all those things are unconstitutional, which means things that desegregation has to occur. The legal protections for it have now been removed. This is a dramatic ruling. The courts know that. And as Earl Warren says, we're just 9 guys in a row. So this is really something that's going to have to be done by the executive branch. And Warren knows it's going to be very controversial. It's going to be difficult for states to do. And so they want to have this idea. There's a follow-on ruling that's known as Brown 2, which gives a sort of timeline. And it says, desegregation must occur with all deliberate speed. Now, how many weeks, how many months, how many years in deliberate speed? That's left open on purpose because the court knows this is going to have to be enforced by the executive branch, and it's going to have to be accepted by the public at the state and local level. So they want to give the suggestion of things happening, but they're not setting a timeline because they know how disruptive this would be. Initially, as Chafe says, the states where this was overturning Jim Crow law were amenable to it, but then they began to dig in their heels. Chafe blames the Eisenhower administration for not enforcing it more aggressively. It did not fit Eisenhower's view of state and federal authority. He believed this initiative should occur at the state level, but that's neither here nor there. Chafe finds that he is a contributor to this resistance. So what happens? The southern states resist. They seek to prevent this desegregation process, particularly in schools. You have in some places, for example, in Virginia, instead of desegregating schools, they shut them down, right? So nobody got educated because of that. In other places, they developed these tricks. So somebody said, I want to send my children to this school because Brown versus Board of Education says my children can go to any school they want. They want to go to the what was called the white school before. So by law, the school has to admit them. So you have places where what happened was they admitted the black students who enrolled to the school, but secretly they contacted all the white parents and they said, we're opening a private school where all the teachers are going to be teaching and we're inviting you to join this school because it's a private school, not a public school. They don't have to adhere to this Supreme Court ruling. And so when the fall semester starts, the black children show up and there's nobody else in the school, it's just them. So these are all attempts to evade it. And it's in transience because they're seeking to evade what the dictates are of the Supreme Court, which leads to what Chafe calls the second assault, right? So the first assault was the court system. They successfully overturned this body of legislation, Jim Crow, through the court system. The Supreme Court overruled Plessy versus Ferguson, removing it, making segregation law unconstitutional. So they win that battle, but then there's a battle of enforcing it. And so Chafe calls this second assault civil disobedience and peaceful protest. This is when the government won't enforce it, then it's up to the people through civil disobedience and peaceful protest to do so. And so he gives some examples of that, and we'll talk about 3 here. First, the Montgomery bus boycott. This is the famous Rosa Parks story. This case, the particular case run like this. There is a bus system in Montgomery, Alabama. The bus drivers were white, and the school and the buses themselves had a line that was drawn in the bus. The front section was the white section. The seats behind that line were the black section. So what happened was when the white section filled up and another white person got on, the people in the first row of the, as they were referred to it, the colored section, would have to get up and give up their seats to the white passengers. It's a rainy day. The bus is driving down the road picking up people. Rosa Parks is sitting in the first row of the black section. She's not challenging the system by sitting in the first row. She's sitting in the white section. She's sitting in the black section. The bus stops at a spot. A white passenger gets on. The bus driver issues his call to the bus, N-word, get up. And the white passenger is walking down the aisle looking to get into the seat that's going to be vacated by a black bus rider. And Rosa Parks doesn't get up. Diagonally across from her, a black man was so startled by her not getting up that he jumped out of his seat, and the white passenger sat down. They went on to the next stop where more white passengers got on. Bus driver issued his call, and Rosa Parks didn't get up. Right? She was arrested. He flagged down a police officer. She was taken off the bus and arrested, taken down to the roundhouse where she received a summons for a fine and then was released. This case, the NAACP in Montgomery decided they were going to challenge it. Right? And this was not the first case of somebody from the African-American community challenging this system of having to give up your seats. As Chafe tells us, there were 2 previous ones. The first one, the young woman had a cousin who was in jail. And so they did not press this case because they were afraid that the arguments would be made that, she's part of a criminal family, blah, blah, blah. Second one, the young lady was an unwed mother. And so they said, this is not a good case to argue because we're going to, they're going to say she's immoral, whatever, right? So Rosa Parks was the third case. And this one they decided to to challenge it in the court system because Rosa Parks was a very fine, upstanding member of her church community. She was very actively involved in local affairs for the African-American community, and they said she's a perfect spokesperson for this challenge. So what happened was they went out on bus boycott. They said, we're not riding the buses until the rules are changed, and they had 3 outrageous demands. Here they are. Demand number 1. A lot of these bus lines go through predominantly African-American communities, but all the bus drivers are white. Can you hire some people from the community to drive the bus lines in the black neighborhoods, right? This will be an opportunity for them because bus driver is a good paying job. And it also would be nice for us. 2, the line that separates the white and black section is static. Could you make it flexible so that on days when the black section is full and the white section is open, we could move the line up so that we could sit down? Because the way things stood now, if the white section was empty and the black section was full, you had to stand. You couldn't sit in the white section if you were black. So that's the second demand. And the third demand, could you ask your bus drivers to be a little bit more polite when conversing with their black riders, right? That was it. Those demands were outrageous to the bus company, who said, we're not talking about it. So the Black community went on boycott. They refused to ride the bus. And one of the things I find very inspiring about this whole business is that when they started the bus boycott, they had no idea how long it was going to last. Nobody said, all right, we have to hold on for a week or 5 days or a month, right? It turned out to be 385 days. Nobody knew how long it was going to take. And every day, those buses ran. So if you were walking to school or walking to work and it was raining or sleeting or hot or cold or whatever, you could get on the bus because the bus was going by, and the Black community still boycotted. More than 90% of the Black community refused to ride, right? So the Montgomery bus boycott is a boycott of this unfair segregation treatment. It's a peaceful demonstration. Also gave birth to Martin Luther King's work in civil rights, because he was a young minister in the town of Montgomery, and he became involved in this bus boycott effort. He went around to a lot of the churches and gave this buck up the spirits talk, keep the faith, we're going to challenge the system. And he became a leading figure because of this Montgomery bus boycott and the civil rights movement. It also led to the creation of the Southern Christian Leadership Council or Conference, right? The second example, the counter sit-down strike. This is in Greensboro. There was an earlier counter sit-down strike right here in Wichita about 2 years earlier. There's a marvelous local PBS show on it, hour-long show. If it ever pops up on PBS, take a look at it because it's fantastic. There's also, I put up a link to some Wichita Eagle articles. The counter sit-down strike was successful here in Wichita, but it didn't spark other copycats like the counter sit-down strike at Greensboro did. So I like the story of the counter sit-down strike at Greensboro as well, because it started with 4 young teenagers, 18, 19 years old. It wasn't a grand plan. It wasn't any national effort. There was no funding from various sorts of folks. They were 4 young men, and they said, this system is unfair. And so they decided they were going to challenge it. And what they did was, it was illegal for a Black patron to sit at the counter in the store and order something, right? That's was also the case here in Wichita. The Dockham Pharmacy had a long counter where you could, get a sandwich or a cup of coffee or something. The Black community could not sit at the counter. They could order at the back door, and they would pass out coffee or sandwiches if that's what you wanted, but you couldn't sit at the counter, and that's what they were challenging. Such was the case in Greensboro. So these 4 young men went into the Woolworths, and it had a counter, lunch counter. They bought some small items, a toothbrush, something or other, right? So they're paying customers. And then they sat down at the counter and asked for a cup of coffee. And the waitress said, we don't serve coloreds at the counter. And so they said, well, we're going to sit here until we get service. So they sat there peacefully all day long. At the end of the day, the store was closing. They got up and left. They came the next day, and there was 6 of them. And they did the same thing. They came in and purchased some small items, sat at the counter peacefully, and didn't get service. By the end of the week, the group who was going into the counter had grown, and they were going to the counter, and as Chafe reports, there was a white mob waving Confederate flags, blocking them from entering the store. And then the football team, North Carolina A&T, formed a wedge and wedged their way through the door to allow the counter sit-down folks to go into the store. And Chafe reports that as they forced their way through the white mob to the door, the white mob said, "Who do you guys think you are?" And they replied, "We're the Union Army," right? So this challenge of the counter sit-down strike, a peaceful demonstration, set off copycats all across the South with other young folks, men and women, challenging the system by sitting at the counter. In many places, they were rudely mistreated. They had ketchup and mustard dumped on their head. There were things thrown on them, sworn at them, hit, but the whole thing was nonviolent protest. The third nonviolent protest that Chafe talks about is the Freedom Riders, right? So the Supreme Court has ruled that it is unconstitutional to have separate facilities. Interstate bus lines clearly fall under federal law because they're crossing state lines. And so the people who called themselves the Freedom Riders, they decided they're going to test whether or not this was being adhered to. So they were going to take buses from Greyhound buses and trailways, and they were going to take them from the north into the south. And they were going to, when the buses stopped, they were going to go in and use each other's bathrooms, the colored and the white, and to challenge the system to see if the law was being adhered to. Right? What the Supreme Court had ruled, this stuff was illegal. And then, for good measure, they said they were going to stop in Mississippi, where they were going to enroll as many Black Mississippians as they could to vote. Right? So that's what the Freedom Riders are doing. So again, it's a nonviolent protest. And the Freedom Riders were nonviolent protesters who were met with extreme violence. Right? In the case of one of the Freedom Rider buses, the Kennedy administration decided they were going to seek some sort of measure of protection for these Freedom Riders. So they put a United States Marshal on one of the buses to show you couldn't stop these folks because they were operating legally, and a U.S. Marshal was a representative of the Kennedy administration saying we support their right to do so. So the bus was outside of a town where it was met by a mob, right? And the mob stopped the bus, and then to encourage people to get off the bus, they threw in a Molotov cocktail. And as the people streamed out of the bus, they were beaten by this white mob. And then about 10 minutes later, the sheriff's department showed up and put a stop to it. U.S. Marshal had a fractured skull out of this whole thing. So this nonviolent action was met with extreme violence, which was widely broadcast, right? And so this second wave of challenging segregation through nonviolent civil disobedience achieved what the first wave, or achieved what Reconstruction did not, right? Reconstruction failed because it didn't change white Southerners' minds, or for that matter, white people's minds in general in 19th century America. But especially Reconstruction failed in the South because the defeated white Southerners refused to accept the ideas of equality. And they never changed their mind. They were resistant, and it ended too soon and didn't work deep enough to change people's minds. Civil rights succeeded, not completely, but where it succeeded was, I think, in the greatest thing, it changed people's minds all across the nation. Because segregation is a system that relies upon violence to keep another group of folks in an inferior position. Enough people, when faced with this violence that is inherent in the system to keep people subjugated, when people were forced to confront what segregation means, what Jim Crow means, this inequality, this system of inequality, which was being enforced by local authorities, it convinced enough people to change their mind on it. This is not what I envision. So the civil rights movement, as Chafe tells us, becomes a template for other protest movements. You have the women's rights movements, gay rights, Latino rights, all adopt this civil disobedience approach to force people to confront this, the inherent violence of keeping people separated on some sort of justification. It also is a method of protest that's adopted by protesters against the Vietnam War. And so this whole system is built upon forcing the nation to confront what their policies mean. Okay, that's where we are for that. Next, I'll pick up with lecture 3 from Gaddis.